to Class 1 of Trial Advocacy. I'm going to talk to you about the mechanics of a trial, what goes on in a trial. This lecture or the first half of this lecture is from Chapter 1 of Maui, and also, the second half is from Chapter 2. So there are a number of things you need to be aware of in conducting a trial in any court. So you need to be aware of the rules of that jurisdiction, state or federal and local rules. You need to be aware of the rules of that court. So in Massachusetts there are kind of a lot of different courts, especially in the state system. So there are 7 trial court departments, and I bet I couldn't even name them all. Superior Court, District Court, Boston Municipal Court, Land Court, Probate and Family Court, Juvenile Court. That's 6 of the 7. All of them conduct trials, and all of them have their own rules. And some of the courts have rules that are called standing orders or guidelines. So you need to have some sense of those, although it may be impossible to really be on top of all of these, what I'll call local rules. The Federal District Court also has its local rules. So for example, the Federal District Court for the District of Massachusetts has its own local rules. And for all I know, there's a court in Boston, a Federal District Court in Boston, Worcester, in Springfield. For all I know, I don't know, but for all I know, they each have their own rules. So you need to have at least some sense of these different rules, although it might be impossible to really be up on all of them. Very important, though, and a significant practice advantage are the idiosyncrasies of the judge. So when you're going to try a case in front of a judge, you want to find out any way you can about how she tries the case. Ideally, this may not be realistic when you have a busy, crazy practice. Ideally, you go in and you watch her conduct the trial. And I'm going to close the door just because I don't want any extraneous sound on YouTube. But it's enormously valuable to watch the judge as she conducts a trial, because judges do it all sorts of different ways. Judges come into being a judge having tried cases all sorts of different ways and all sorts of different levels of experience and backgrounds. Another good way to find out about how a judge tries a case is to ask people who appear in front of that judge all the time. And there's one judge who's now retired, who I won't mention in this, what amounts to a very public forum, who would not let you, if you were talking to the judge at what we call the sidebar, and I'm stepping out of camera range, would not let you touch the bench, and would get upset if you did that. So there were lots of little traps like that. Finding out how the judge tries a case, or that makes it sound like the judge is really doing the hard work, but the judge isn't, of course. Finding out how a judge hears a case will also calm your fears, because when you start out, you'll be, I imagine, enormously nervous about trying a case, and unless you're really kind of a sociopath, you probably retain some nervousness throughout your entire careers. So it's a good idea to find out about what the judge is like, or even observe her, in order to calm your fears and get used to the experience. So at the beginning of the trial, before almost anything is done, you often will deal with motions in limine. And you're undoubtedly somewhat familiar with this idea, but it is a motion in limine simply is a motion seeking an immediate, or it's some sort of Latin or Greek, I don't really know, about at the threshold of getting an evidentiary ruling very early in the case. And it can be very helpful for a lawyer, especially an inexperienced lawyer, because like going to watch the judge, it tends to calm your fears, because evidence law is difficult, number one, and it's also very difficult to do on the fly. So motions in limine are a good thing if you're inexperienced. If your opponent is less experienced than you, then they might not be a good idea, because then you have the advantage. So after you do motions in limine, which can be oral or written, by the way, you go into jury selection. Jury selection really is beyond the scope of this course, but I'm going to tell you a little bit about it. Jury selection is difficult to do in practice, so I'm going to suggest to you you have to really do it to learn how to do it. And that at least my experience has been that my description to you of jury selection will never teach you how to select a jury. But there are a number of different ways of selecting a jury, including method, and I'll just give you a sample. So one way is to bring each juror up and question that juror, each potential juror. Maybe the judge does all the questioning, maybe the lawyers do all the questioning, or maybe a combination. And then each juror who is approved goes and sits in the box. And then once the box, or I should say the box is where you're sitting, then when the box is full, the lawyers, perhaps in alternating order, challenge jurors using challenges for cause, and then peremptory challenges, or challenges that they don't need to have a reason to exercise. Another way is to fill the box and conduct a voir dire, or questioning of potential jurors, just as if I were one of the lawyers, and I would go and talk to whichever ones among you that I wanted to talk to about your experiences and your feelings about issues that might tell me something about how you would rule, how you would decide the case. That is a more modern way, and it requires, I'm going to suggest to you, some experience in how to talk to jurors in order to be effective. You need to, in that kind of jury selection, you need to ask open-ended questions, and you need to have had some practice and training in order to do it well. So after jury selection, which I totally have not done justice to in my discussion now, after you have the box filled and you're about to start the trial, the judge will normally give preliminary instructions of law. And those instructions would be, whether it's a civil or criminal case, the basic elements of the claim or criminal charge, just the basics, possibly some key defenses, like just the basics, a very skeletal presentation of those things. And then you have opening statements. So in the opening statements, the opening statement and the closing arguments have some parallels. The key difference is that an opening statement is supposed to be a presentation of the evidence that is to come, and not argument. Now, theoretically, there is a pretty clear distinction here between an opening statement and a closing argument. So every once in a while in the media, you will hear a media reporter say, well, today they gave opening arguments in the Enron case. That's an error, because it's opening statements of the evidence, and closing arguments. On the other hand, despite that distinction, there is something to the idea. Well, I'll say it plainly. The way I see it, a good lawyer, a really good lawyer, does some argument in his opening statement. A really good lawyer does some argument in his opening statement. It's up to that lawyer to do it so that the lawyer does not lose in front of the jury very much, in the sense that the judge doesn't go nuts on the lawyer for doing what is arguably doing something that's a little bit improper. But a good lawyer does some argument in the opening statement. It's a question of judgment and, I suppose, experience on how much argument the lawyer does, but some argument in the opening statement is recommended, and it's something to be done carefully. So the first person to give their opening statement is the party with the burden of proof. But the defendant should always give, or I shouldn't say that, the defendant should almost always give an opening statement. To not give an opening statement is to give up a valuable piece of artillery. The defendant can, in all the jurisdictions that I know of, give an opening statement right away, right after the plaintiff or prosecutor's opening statement, or wait until the beginning of the defendant's evidence. A lot of times, the defendant doesn't have any evidence, so it might not be a good idea to wait for that reason, to wait until the beginning of the defendant's evidence, but it also is not a good idea because you want to answer the plaintiff or prosecutor's opening statement right away. In an opening statement, one should not burden the jury with too much law, and the judge might not even appreciate it. The judge may give you a bit of a hard time if there's too much law in your opening statement. Let me stop here and tell you something about a good trial lawyer's relationship with the judge. A good trial lawyer should not be, and I'm not talking about what a good trial lawyer is trying to appear to be doing, but a good trial lawyer should not derive her self-esteem from how popular she is with the judge. A good trial lawyer does her job without worrying about whether the judge likes it or not, and makes decisions based on what works and what's good with the jury. So the simple fact that the judge gives you a hard time about arguing too much, or the simple fact that the judge gives you a hard time about too much law in your opening statement is not a consideration I recommend to you. So you need to shed the idea that I want to be popular with the judge, because you don't want to be popular with the judge unless it, forgive the sports analogy, unless it moves the ball forward for you in winning the case. You want to be popular with the judge only if it helps you to win, not because there's any inherent good in being popular with the judge. The heck with the judge. Your job is to win. If not at trial, on appeal. I want to tell you about a modern opening. You'll remember at the beginning of this real class, not on YouTube, I said, I want something like, I want you to have communication skills like a YouTube star with 5 million hits on their videos. I said that because I said that as part of a modern opening. So in an old-fashioned opening, and it could be that this is so old-fashioned that you folks don't even have to burden under this baggage. Under an old-fashioned opening, I would have said, my name is Jack Lew, and I'm a professor at this esteemed law school, and I welcome you here today. We will discuss a lot of interesting topics, and I guess I'd tell you about my background. When I was a lawyer, I tried lots of cases, and I've been a trial lawyer for a good long time. That would be an old-fashioned opening. Not so bad, actually, but a better opening is the modern opening, where I grab onto primacy, and I use primacy. And then you're going to remember that. You're not going to remember that I tried a lot of cases. Why do I care about whether you remember whether I tried a lot of cases as a lawyer? But I do want you to remember when you're trying some case later on in your career and you're under incredible stress and you think your head's going to explode, I want you to remember to talk like you're on YouTube. Because if you watch these people on YouTube, they're great. They're fantastic. So a modern opening, really, in a nutshell, a modern opening, or a modern opening to an opening, or a modern opening to a closing argument, or a modern opening to a speech, a modern opening to a YouTube video. You know, I didn't get it from YouTube. I knew this before I read some stuff about YouTube. But do you know what they say? They say, if you want to be a YouTube star, in the first 10 seconds of that video, you got to grab people. Otherwise, they're on to something else, something better. So the modern part is that you jump right into it, and there's no prefatory remarks, no lawyer-like stuff, shirt stuff. You just get right down to it. So I have a list. I think it's on the next class's a portion of Blackboard. There are a list of naughty words. So these are words that I really don't want you to use in the course of this course. All right? And the worst one of all, may it please the court. That's the worst one. Don't say that. But there are other things, legalisms, legal jargon, police language, things like that. And so you'll see that on the next class's portion of Blackboard. So in an opening statement, as with a closing argument, there's some disagreement about this. And the just plain old truth is that some wonderfully experienced and smart lawyers and judges disagree with this. But I'm going to suggest here that in an opening statement, a theme, that's maybe not too controversial, and emotion are essential. So not everybody agrees with that, but that's what I recommend to you based on what I've seen. And so what's the counter-argument to that? Well, the counter-argument to that really is, well, what if you're trying this incredibly boring case? How can you plausibly talk about emotion or a theme? So what's the most boring kind of case you can try? Probably an eminent domain case would be right up there, you know, where the city is trying to take your land and you're trying to get just compensation or something like that. Even there, a lawyer can talk about, you can definitely talk about it in your closing argument, and you can get away with some talking about the rule of law and what is just and fair, and even if it's something as boring as an eminent domain case. So what I recommend to you is theme and emotion in every opening statement, yes, every one, and theme and emotion in every closing argument. And if that's the case, then you're going to have theme and emotion throughout the case, because that's where the ammunition comes from for the closing argument. Storytelling is important, very important for the plaintiff or prosecutor. So the person who goes first pretty much has to tell a story, give an account, try to be the leader of these folks in the jury box who are to decide this case. But much the same applies to the defendant or the person who doesn't have the burden of proof in their opening statement. I'd strongly recommend, as best you can, to use what storytelling skills you can learn and gather and create from your view of the case. So the plaintiff or the prosecutor then presents evidence, a witness by witness. So witness by witness, we proceed by direct examination of the witness by the person calling that witness, the side calling that witness, which should be, for the most part, non-leading questions, questions that do not suggest their answer. At the beginning of the examination, leading questions are more permissible, and for transition, they are more acceptable as well. Transition from area to area in the witness's testimony, and also, as a reality, much of the time, you will find that everyone wants to just get things done faster, and a fair amount of leading might or might not be allowed, just as a practical matter. On cross-examination, the scope of cross-examination in federal court is limited to the scope of direct examination, so that's in federal court, but in state court in Massachusetts, it's completely different. On redirect, The scope of redirect is limited to cross, so you can't bring up new things. On recross, the scope of recross is limited to the scope of redirect. So the plaintiff or prosecutor calls whatever witnesses the plaintiff is going to call, and we have cross-examination and what follows for each of those witnesses. Then when the prosecutor or plaintiff rests, the defense will often move for a required finding of not guilty in a criminal case or for a directed verdict in a civil case. If the jury is excused and there's a legal argument about the evidence in the light most favorable to the non-moving party. Then the defendant presents their witnesses if they have witnesses, and you follow a similar chronology, and the defendant rests, and the defendant may well represent a motion for a directed verdict or a motion for a required finding of not guilty. It is possible for the prosecutor or plaintiff to present new evidence based on the case presented by the defendant. It is rare, and it is possible. I think the book makes some reference to a surrebuttal. It is possible for the defendant to respond to that. I have never seen it. I've been a judge for 14 years. Or if I have seen it, I've forgotten it. That's how rare it is. And then you do the charge conference, which is a fairly detailed discussion of the jury instructions. Jury instructions are very important to trying a case, and they have to be done in order to preserve your objection. You have to do them in a very particular way so that the judge is presented with a very clear choice on what it is you're asking, and you have to renew your request for each jury instruction of any consequence after the judge has instructed the jury. And then you have deliberations and a verdict. So that's the basic, maybe kind of boring chronology of a trial. Let me talk to you now about what comes from Chapter 2 of the Maui book. And this is about the psychology of persuasion. So the Maui's wonderful book talks about effective reason. And this is reasoning based on emotion. And I couldn't agree more with him that this is essential to trying every single case. So what this translates to is that every opening should appeal to emotion, and you should do your best to shed every aspect of you that has learned this great new language that you've learned, and this great new academic discipline, and this ability really to speak like the high level graduate students that you are, and talk as they say. If you haven't heard this already, you should be talking like you're talking to your grandmother at the dinner table, but maybe a little bit more polite than that. That's the level at which you're talking. And to the extent that I'm not doing that, then I'm falling down, I'm falling down in my job, because that's what I'm trying to do in talking to you. But I am handicapped by the fact that I'm talking to a group of graduate students. But if I were to do my job the best, I'd be talking just almost like I do at home at the dinner table. That's how regular you need to be. Primacy and recency. You know about primacy. And recency is that you remember what you're told last. So I won't fit it into my talk today unless I have an unexpected, unless I had lots of coffee and I'm really raring to go. But the last thing I say when I go to shut the camera off, you'll probably remember that. And you'll remember the first thing I said, which wasn't on camera, I think. Or you're much more likely to remember the first thing I said. And you're much more likely to remember the last thing I said. It's important that you have an opening. It's important that you have a strong opening, because you don't want to surrender that battleground. I think the way Maui the way Maui describes it, he's much more of an intellectual than me. He says, don't surrender the early conclusions that the jurors make about the case. There's a lot made of the early conclusions about that jurors make of about a case. It may be too much, but there is something to that. That the early conclusions that the jurors make, they often stick with those for the whole case. So you want to come to that opening statement ready to really contest the case fully. And don't give a perfunctory opening statement. Pre-existing juror attitudes are very important in decision making, but don't have the idea that by looking at the relatively bare demographic information that you might have, that you can make some huge conclusions about how jurors think. It's a mistake made over and over again that demographic information, even if in the jurisdiction you're in, you get pretty good demographic information, don't jump to conclusions about the kind of people you're talking to. Because that demographic information, more often than not, will lead you down a dead end in terms of the kind of person that is deciding your case. So be aware of the dynamics of group decision making. The jurors, and this goes for witnesses as well, and you should keep this to some degree in mind, jurors are nervous and anxious at the beginning of a case. So a lot of times, even with witnesses, but certainly with jurors as well, it may be a good idea to address that in the way you handle the case. So it's a parallel to this course. You know, I tried to say something at the beginning of this first meeting, not on videotape, about how, you know, let's not get nervous about what we're doing, or not excessively nervous. We'll all be laughing at each other. You know, I'll come in one day late, or I'll come in late and you'll see I have a coffee, so I took a detour that made me late for class, or I'll forget something, or you'll ask me a question and I'll have no clue what you're talking about. So we'll all be laughing at each other. I tried to make you feel comfortable. So in your opening statement, you can incorporate that, trying to make the jurors more comfortable with this new role, because it is very foreign to them, and yes, believe it or not, it causes them anxiety. It's totally true of witnesses, and I'd recommend trying to incorporate it for particularly nervous witnesses. The foreperson is not necessarily key, although in some states like Massachusetts, the foreperson is usually immune to being selected as an alternate. So you know the foreperson is the only person that's going to definitely be there to decide your case. The foreperson is often a successful, educated person, if chosen by the judge, or even if voted in, depending on the jurisdiction. The foreperson is often an educated, successful person who's not really trying to achieve a result, guilty, not guilty, responsible, not responsible, but more often is trying to just achieve a consensus result, whatever the actual result may be. I didn't articulate that very well, but in other words, the foreperson may not change the direction much of the jury. Don't think that they're crucial necessarily to what is going on there. So be aware of or try to get a sense of what the jurors are like. So in jury selection, you may see who might be persuaders, or people who are relatively assertive, maybe more educated, and try to key your trial of the case to them. You want to, during the course of a trial, at all, you know, in the American cultural milieu, I always work that word into my YouTube presentations, but don't you dare use it in front of the jury. You're going to want to try. We judge people based on eye contact, somewhat. So every single juror at pretty much all or varied parts of the trial, you want to be making eye contact. So if I haven't been making eye contact with somebody, I think I have, I'm making sure you're not sleeping, but you want to make eye contact at various parts of the trial with everybody in the jury box. And you want to do that particularly with the people that you might, depending on the jurisdiction and the amount of information you get about folks and how much you're able to talk to them during jury selection. You may want to key in on the people that you think might be persuaders. It's important that the senders of the information, the lawyers, have good communication skills so that they have credibility, expertise, and dynamism. So I'm doing my best to exude those things. I'll be a little better once I get to know you, I think, but those are important things. So credibility, yeah, that does mean you don't take stupid positions during the trial that the jury learns of. You know, a lot of the trial the jury sees, and if you take stupid, kind of frivolous positions, then that undermines your credibility. If you seem to lose all the objections, yeah, it does. I mean, it's important that you not try to be friends with the judge and that you be totally willing to take on the judge. It's not your job to be pals with the judge. But the truth is, if you lose every objection and the jury figures that out, they don't necessarily understand what the judge's ruling is on every objection, then that undermines the idea that you have expertise. So, and then there's dynamism. You know, this guy, Irving Younger, you've heard of, I hope. He died at a very young age. He was this law professor judge who would get up on, I don't know if I'm on the video, but he would get up on the table and talk to people like that. See, that would be dynamism. All right, I'm not in the hospital yet. That would be dynamism, or at least a weak imitation of dynamism. If so you need to understand that a key part of good communication skills, and my telling you this isn't really going to communicate it, I fear, if you're like every other student, lawyer, and human being I've encountered in my life. And that is, you've got to be really short. Because in real life, for one thing, well, it may be a parallel to you right now, but in real life, the jurors have other things they'd rather be doing, with some rare exceptions. And so they're not interested in an extra 10 seconds of your opening statement, witness examination, or closing argument. You know what? We go and we talk to every juror. We go and we talk to every jury after every trial. And you know what's always going to get a big laugh from them? Is if we say, if I go in, you know, I'm maybe with a court officer and a law clerk, and we chat after the verdict with the jury, while they're in the jury room, right after the verdict, right after the case is over. And if they ask a question that's a little bit hard, if I say to the court officer, could I have a sidebar on that? They will break out laughing like crazy. Why do they break out laughing like crazy? Because they're enormously frustrated, almost always, with how long the trial took and how the lawyers, usually all of them, took way too long. Way too long. So I want to start now by telling you you need to be really, really short with everything you do. That's a key part of having good communication skills. So you need to be fast, and it needs to be painless, interesting, and visual. That's a tall order on that eminent domain case, but the fast part, it needs to be faster than you ever imagined, I'm going to suggest to you. It needs to be pretty painless. There may be limits to that. And it needs to be interesting. You need to make it interesting. So if you can't make it interesting, then it's probably your failure. If you can't, I'll say that again, if you can't make it interesting, it's probably your failure, and it needs to be visual. So maybe in the course of this course, we're not going to be able to do the following. But if you're out there trying a case, and you don't have some big blow-ups, and I mean, so off the floor, I mean about this big, that tall. If you don't have some big blow-ups, then you're not trying your case properly. You know, 10 years ago, maybe cost was a consideration and that wasn't okay. But nowadays, if you're trying a case in practice, then you need to have blow-ups about this big, period. And if you don't, then then you're really just not doing your job, because it needs to be visual. That is a good communication skill. You know about primacy and recency, and that's true of primacy and recency in the trial. So the first thing I say at the beginning of my opening statement, that's primacy. And the last thing I say at the end of the closing argument, that's recency, right? Those are the things you remember. But also within the components of the trial. So let's pick something at random. My cross-examination of John Smith, the first words that come out of my mouth, all ideally, should be important, significant, something I want the jurors to remember, recency. And, I'm sorry, that's primacy. Primacy would be the first things I say on cross-examination of John Smith. And recency, hopefully the last thing I say to John Smith will be something that is important, memorable, and that matters to my case. And that way I'm using my ammunition in the trial effectively. You also should be aware of the idea of forewarning and inoculation. So, for example, the prosecutor or plaintiff should, yes, forewarn the jurors about what is coming from the other side. Now, that's obviously not necessarily an easy thing to do, and probably quite difficult for a plaintiff or prosecutor to do if that lawyer is not experienced. But it is a desirable thing to do if you can. So a couple of things about, and this applies mostly to closing arguments, but so the theory of the case is critically important. And the theory of the case is difficult to do. And Hannah will remember that, I help out with the mock trial team. We spent a lot of time, half of it I'm sure, more than half of it, without me even being present, filling up, this is probably off camera, filling up these blackboards here, scrawling on pretty much every inch of the blackboards, and hashing out theories of the case that change over a month or two of preparation of a mock trial fact pattern. So the theory of the case is a very difficult thing that you have to work hard at in order to do a good job. It should be persuasive and it should be comprehensive. Comprehensive means that it has an explanation, whether explicit or implicit, for every piece of evidence. If I almost, at the beginning of this, when I talked about the YouTube stars and their communication skills, if I wasn't going to get into that, I think maybe one of my sons was watching YouTube a lot lately, and the idea occurred to me. I could easily have said, the theme of this course is good communication skills. If there's, perhaps the number one most important thing about trying a case is to have a good theme. Now, theme and emotion are somewhat related. And there is some folks, as I said, very smart, experienced people who think you can do too much of it. I respectfully, well, I suppose I agree you can do too much of it, but where I draw the line is a lot more towards lots of theme and emotion than what I would describe as a minority of lawyers and judges. So the theme is very important. It needs to be persuasive about the elements, inferences, defenses, and credibility issues in the case. So the theme really is something that should capture the entire case. It's very important, and when you do your closing arguments, I can almost predict that that theme will be something we'll want to talk about a lot. So theme is critically important. It needs to be emotional, at least to some degree, and it needs to explain the facts. The closing argument the closing argument in the entire trial should also explain all of the facts. The closing argument can also rely upon what Mawe calls time-honored sources that contain universal moral truths about life. So you can, even though in a way it doesn't make sense, you can do hokey things, like in your closing argument, and like quote what your grandmother says. I'm big on grandmothers today. But that is allowed. During the trial and in your closing argument, you should be sensitive to labels. So you should consciously adopt certain labels. So let's say I am the defense lawyer in a criminal trial. The prosecutor is never going to be Ms. Smith or Jenny or whatever her name is. And the prosecutor is always going to be a faceless monolith. And by that I mean the prosecutor in mass state courts, the Commonwealth, or in federal court, the government, or maybe in state court, the government also. You're going to adopt any labels that dehumanize, or at least don't humanize the other side. So if you're the defense, it's the prosecutor. And if you're the defense in a civil case, it's that plaintiff. Emphasis on that plaintiff.